So these are the facts in HA Iraq. As would be expected, appellants are non-British nationals. If they were British, they couldn't be deported, had been living in the UK for many years. Both appellants were in settled relationships with British women, and both had young children who were also British citizens. Both had committed criminal offences, and the imprisonment terms were 16 months and 12 months respectively. So we're looking at the medium threshold for deportation, not over 4 years, and obviously not under 12 months. The case was heard at the upper tribunal by a presidential panel. Both appellants had succeeded at the FTT. The Secretary of State appealed, and those appeals were then heard by the presidential panel. And the intention was that the panel would give authoritative guidance on various issues in relation to Section 117C of the 2002 Act, arising out of the then recent decision of the Supreme Court in KO, Nigeria. Next slide, please. So having set out the facts in the judgment, the judgment then goes on to set out the background to deportation law and the current regime in quite a bit of detail. I don't propose to go through all of that in detail because it's way beyond the scope of this update. But if I can just refer to the relevant paragraph numbers of the judgment, it starts at paragraph 7 with the background law. You have sections 32 to 33 of the 2007 Act, which is the automatic deportation provisions. Section 55 of the 2009 Act, the duty that the Secretary of State has to safeguard and promote the welfare of children. Then reference to 3 cases from the Supreme Court that set out in detail what that entails, and in particular, paragraph 10 of Zumbas, Lord Hodges' summary of the 7 propositions relating to the best interests of children are set out at paragraph 10, and certainly an essential reference point when preparing and presenting deportation appeals. Then from paragraph 12 onwards, part 5A of the 2002 Act, section 117C. At paragraph 22 onwards, you have the immigration rules, which mirror part 5A of the 2002 Act. And then at paragraph 26, Lord Justice Underhill begins with an overview of the law with respect to deportation. In paragraph 27, you can see the point made by Lord Justice Underhill that the purpose of the statutory scheme, and this applies as much to the immigration rules as it does to Part 5A of the 2002 Act, is to adopt a structured approach to the Article 8 issues raised in deportation cases. It is not to prevent the proper application of Article 8. And at paragraph 28, it follows that the Strasbourg case law about the application of Article 8 in cases of this kind must and can be accommodated within the statutory structure. It's clearly, from all of the cases, domestic cases on deportation and Article 8 generally, a theme, unsurprisingly, running through them all is that the Strasbourg case law remains relevant and applicable. But as will become apparent from a consideration of the European Court of Human Rights decision in Unane, one of the key questions is, what does that mean? And especially in the context of a structured approach that is supposed to, in the generality of cases, deal with Article 8 issues so that the cases left over that fall outside of the statutory scheme, outside of the Section 117C exceptions and the exceptions under the immigration rules, those cases are supposed to be a small number. Is that consistent with applying the Strasbourg case law in the way that Article 8 requires the courts to, the European Convention and the Human Rights Act requires the courts to apply Article 8. Next slide, please. So paragraph 36, again, Lord Justice Underhill underlines the principle that the assessment of Article 8 has not changed in light of the new statutory scheme. The outcome that is expected should still be that where Article 8 cases would have succeeded previously, they would succeed under the new regime. Next slide, please. The key, or one of the key issues of principle then considered in HARR is what does unduly harsh means. That is, everybody that deals with deportation cases will be very familiar with the phrase unduly harsh. It comes up in the immigration rules and in section 117C. And if you're a medium offender, as was the case in these cases, in order to come outside of the automatic deportation provisions, if you can show that the impact upon qualifying children or a qualifying child would be unduly harsh, then deportation is not required. So with respect to what the meaning of unduly harsh is, Lord Justice Underhill at paragraph 50 underlines the fact that this is an elevated test and that it does carry a much stronger emphasis than mere undesirability. The underlying question for tribunals is whether the harshness which the deportation will cause for the partner and or child is of a sufficiently elevated degree to outweigh that public interest. However, at paragraph 52, Lord Justice Underhill recognizes and emphasizes that that does not mean that the test is so high that it is comparable to the test of very compelling circumstances. And at 52, he also says that observations in the case law to the effect that it will be rare for the test of very compelling circumstances to be satisfied have no application in this context. This is extremely important for the assessment of whether the impact on a partner or a child is unduly harsh, because it means that every case needs to be assessed on its own facts, and there is no ground level of ordinary impact on a child that has to be overcome. In fact, what Lord Justice Underhill says at paragraph 53, that you cannot identify an objectively measurable standard by which a case has to be assessed. Every case has to be informed by an assessment of the particular circumstances of that particular child and that particular family. It's paragraph 56. So paragraph 56 of the judgment goes into some detail about what is ordinary when assessing unduly harsh. And what is said in the judgment is that ordinary is capable of being understood as meaning anything which is not exceptional or in any event rare. That is not the correct approach, referring back to paragraph 52 of the judgment. There is no reason in principle why cases of undue harshness may not occur quite commonly. That's hugely, hugely important, because hitherto, I think there was certainly a tendency for, I think, representatives in preparing appeals and also for judges in determining appeals to assess each case and look for something that was out of the ordinary. But here the Court of Appeal is very clearly saying that there is no such case as an ordinary case. Second, if tribunals treat the essential question as being, is this level of harshness out of the ordinary, they may be tempted to find that exception 2 does not apply simply on the basis that the situation fits into some commonly encountered pattern. that would be dangerous. How a child will be affected by a parent's deportation will depend on an almost infinitely variable range of circumstances, and it is not possible to identify a baseline of ordinariness. Simply by way of example, the degree of harshness of the impact may be affected by the child's age, by whether the parents live with them, NB, that a divorced or separated father may still have a genuine and subsisting relationship with the child who lives with the mother, by the degree of the child's emotional dependence on the parent, by the financial consequences of his deportation, by the availability of emotional and financial support from a remaining parent and other family members, by the practicability of maintaining a relationship with the deported parent, and of course, by all the individual characteristics of the child. These passages, and it's paragraph 56 of the judgment in particular that's important, and paragraph 52, take us away from a search for something out of the ordinary in a case. An ordinary case, quite commonly encountered, could still meet the test in 117C6. That's very clear from this judgment, and as my colleagues will tell you in due course, that this decision has been, and this part of the judgment has been reinforced in the two cases from the Court of Appeal that followed HA Iraq. If we can have the next slide, please. This is paragraph 81 of the judgment. And this is how I think this is HA's case, the court then applies this reasoning to the facts of the case. And you can see that the court says it would not be surprising if the emotional and psychological impact of his deportation, HA's deportation, on some or all of his children would go significantly beyond that which any child would necessarily suffer from the deportation of a parent. In other words, for it to be not only harsh, but unduly harsh, the impact would of course be all the greater, given the finding that his children would not be able to visit him in Iraq. In the end, however, I have reached the conclusion that it would be wrong to treat KO as a factual precedent, such that any case with what may appear to be similar facts must be decided in the same way. Each tribunal must make its own assessment. And again, this is taking us away from this baseline level of ordinariness, applying the reasoning of the judgment to the facts of the case. One can see that the court is moving away from factual precedents, recognizing that each case is different and each case turns on its own facts, and therefore, and this of course would cut both ways. Cases where on similar facts there has been a successful appeal would not be something that could be of much use to an appellant. At the same time, cases on similar facts where an appeal has just been dismissed would also not be useful. Every case is starting from scratch, and it's the principles that need to be applied, and then taking those principles, preparing a case fully on the facts and presenting those facts to the judge, and asking the judge to then consider how those facts factor into the best interest of the children and whether the impact on the children would be unduly harsh. And that could be in circumstances which are quite ordinary. There doesn't need to be particular types of cases that are out of the ordinary. It's a question of focusing on the particular facts of each case. Next slide, please. This was another issue dealt with by the court with respect to whether the length of sentence has an impact on assessing proportionality. If we look at the medium range of 12 months to 4 years, there is a huge range of sentences that fall into that group. And of course, beyond that, you can have a sentence that is just beyond 4 years, and also a sentence that is well beyond 4 years. And the question before the court was, is that something that should be taken into account, or does the fact that you've got a sentence within that within those parameters, is that the only thing that the court needs to consider? And the answer that the Court of Appeal gave was that it does matter, and that therefore it cuts both ways. The more serious the offence, and therefore the more serious the sentence, that can have a greater weight on the public interest. And at the same time, if the offence and the sentence is at the lower end of the scale, and so, for example, in one of these cases, the sentence was 12 months and the other was 16 months, that is the lower end of the 12 months to 4-year scale, that must also have an impact on the public interest and the overall balance reached in assessing proportionality. Next slide, please. Paragraph 141 is the final part of Lord Justice Underhill's judgment that I would like to look at. And this is in relation to rehabilitation. And again, looking at the situation outside the rules, balancing Article 8, so we haven't succeeded under 117C in relation to the two exceptions. When you are balancing the proportionality, the fair balance to be reached in the proportionality assessment, evidence of rehabilitation and thus of a reduced risk of reoffending cannot be excluded from the overall proportionality exercise. So again, that is something, if you can show it on the facts of the case, that is going to weigh in favour of an applicant's Article 8 claim. It won't have, and Lord Justice Underhill is careful to make this point at paragraph 141, that it isn't going to be decisive. It might not, on the circumstances, be of a huge amount of weight, but it is significant. And of course, when you're preparing scales and balancing public interest against the impact on the family, everything counts, and every bit that you can put on the scale, on the side of the scales for the appellant, will help weigh down that side of the scales to result in a positive outcome for the appellant. And therefore, this is something that is relevant. It can, of course, depending on the facts, again, have varying amounts of weight, but if you're able to show that there has been rehabilitation, both in terms of attitude, courses undertaken whilst in prison, and then after release, if there has been a period of residence during which there has been no further offending, perhaps expert evidence to show that the likelihood of reoffending is diminished, and it would be great, of course, a low risk of reoffending is the best case that could be advanced, and then other aspects of behaviour that shows positive evidence of rehabilitation. All of this works in favour of an appellant seeking to avoid deportation. Next slide, please. Finally, I'd just draw attention to some very important points made by Lord Justice Peter Jackson in his concurring judgment. And this is about assessing the impact on children, the best interests of children in deportation cases or any cases. And this is from paragraph 156. There are two broad ways in which it seems to me that a decision maker may inadvertently be deflected from giving primary consideration to the best interests of the child of a foreign criminal. One is by focusing on the position of children generally rather than on the best interests of the individual child. This goes back to the baseline level of ordinariness. But this other aspect is also, I think, extremely important and something that should be focused on when preparing appeals, and that is by treating physical harm as intrinsically more significant than emotional harm. For some children, the deportation of a largely absent parent may be a matter of little or no real significance. For others, the deportation of a close caregiver parent, where face-to-face contact cannot continue, may be akin to a bereavement. So the specific circumstances of a case, and it's really important to get evidence of the circumstances in which the child or children find themselves in, other life events and circumstances that have an impact on how they would cope with the separation from a parent, and the impact on that child in particular. Then there is reference to the extract from another Court of Appeal case of Lee, in which Lord Justice Sedley said, and the extract that is often quoted is, "That is what deportation does." But Lord Justice Peter Jackson looks at that passage as a whole, and the passage is in bold. "The tragic consequences that this family, short-lived as it has been, will be broken up forever because of the appellant's bad behavior. That is what deportation does. Sometimes the balance between its justification and its consequences falls the other way, but whether it does so is a question for an immigration judge." So it isn't just a blanket statement that separation is what deportation does. That statement was made in the context of a very specific and particular set of facts, short-lived family life, and in those circumstances, Lord Justice Sedley said, this is what deportation does. That does not mean that just because deportation has an adverse impact upon family life in the best interest of the child, an appropriate response from the respondent or from the judge is to say, well, that's what deportation does. That's not the proper approach. One has to look at the particular facts and balance the offending, the public interest weight, and the impact on the child, the children, the wife, the family generally. Next slide, please. And then this is paragraph 159. Again, I think a very useful paragraph to focus on, because the tendency, in my experience, is to treat physical, as Lord Justice Peter Jackson seems to also think, to treat physical harm and physical consequences as somehow more serious and more compelling and more weighty than emotional and mental health consequences. And he says here, my other general observation concerns the treatment of emotional harm. Section 31(9) of the Children Act 1989 defines harm as ill treatment or the impairment of health or physical, intellectual, emotional, social, or behavioral development. There is no hierarchy as between physical and non-physical harm. It must therefore always be recognized that for the child, the consequences of going with both parents may be experienced as far less harsh than staying with one parent. Despite this, it may be easier for decision makers to envisage the harm that may be done by expecting a family to experience precarious or even dangerous physical conditions than to factor in at full worth the lifelong emotional harm of terminating the relationship between a child and a close parent during the child's minority and possibly forever. Provided the decision maker faces up to the reality of the child's situation and gives it primary consideration, the public interest in deportation may prevail, but it will not do to minimize the emotional impact on the child of the severing of ties by reference to the doubtful prospect of maintaining relationships over many years by indirect means only, or by reciting the fact that this is what deportation does. The question posted by somebody, I think, about the ability to get evidence. And of course, getting evidence is difficult for appellants in any event because of lack of funding and the circumstances. If you've been convicted of a criminal offence, you're subject to deportation, resources are going to be probably the premium for most people. I thought I'd just point out something else that from Lord Justice Peter Jackson's judgment in H.A. Iraq, which I think is extremely interesting and builds on previous case law, perhaps taking it beyond those cases. The cases I'm thinking of, which some of you, most of you, perhaps all of you will be familiar with, are judgments of the former president of the tribunal, Justice McCloskey, in J.O. and others, about the Section 55 duty from 2014, and then the 2015 follow-up decision of M.K. Sierra Leone. And that deals with the duty upon the decision maker pursuant to Section 55, what that duty entails and what tools there are available to the tribunal in order to ensure that that duty is being properly discharged in circumstances where proper evidence sometimes is not before the tribunal, enabling it to give full and proper consideration to the factors required to be considered pursuant to Section 55 and the Article 8 duties. So paragraphs 152 to 155 of HA Iraq address this point. And the points, very quickly, are that Parliament has enacted two important public interests involving children. That's Section 117C, and the requirement to assess whether the impact of deportation will be unduly harsh on a child or children, and Section 55 of the 2009 Act, which requires the Secretary of State to make arrangements to ensure that in her immigration functions, she has regard to the need to safeguard and promote the welfare of children, and that's safeguarding and promoting the welfare looking to the future. The decision maker must bring both of these elements into play. And the responsibility for doing so is on the decision maker. Next slide, please. At paragraph, I think we'll skip one, paragraph 153, the Lord Justice Peter Jackson sets out a couple of points from Zumbas, and the requirement that a decision maker must have a clear idea of a child's circumstances and what is in a child's best interest before asking himself or herself whether those interests are outweighed by the force of other considerations. There is no substitute for a careful examination of all relevant factors. A child must not be blamed for matters which he or she is not responsible, such as the conduct of a parent. Next slide, please. Paragraph 154, to these I would respectfully add that the Section 55 duty falls on the decision maker. A child would not usually be in a position to urge his or her point of view, and the decision maker cannot treat the child as if he or she had some burden of proof. And at 155, the assessment that has to be carried out is therefore one that is adequately informed and specific to the individual child as a person distinct from the offending parent. It requires the decision maker, as part of the overall assessment, to look at matters from the child's point of view. In the case of exception 2, the question explicitly concerns undue harshness to the child. And I think the flavor of this part of the judgment is that there is a duty upon the decision maker to ensure that all relevant factors are taken into account and to ensure that the Section 55 duty is discharged. In the first instance, that is the Secretary of State. And in order to properly discharge that duty and to be in a position to ask the right questions, the Secretary of State has to be in a position that she can take into account all relevant matters. Arguably, she cannot rely on the shortcomings of the child's parent or the child's parent's representatives to fall short in her own duty. And that must surely then follow on for the first tier tribunal and the upper tribunal, because Section 6 of the Human Rights Act places a burden of duty, legal duty, on the tribunal to ensure that it doesn't act in a manner that is inconsistent with Article 8 rights. And therefore, all of these obligations to ensure that a decision maker is fully informed must also, in my view, fall onto the tribunal. And it will be interesting to see if there is any development in case law on the way that this is now used by practitioners when appearing before the tribunal, because often it is difficult to get evidence. As I think some of the questions on the chat function have raised, sometimes evidence is not available because witnesses are not cooperating, sometimes because of a lack of resources. And that is an interesting issue when one is looking at the responsibility of the tribunal and the Secretary of State to take into account all relevant factors.